Question 1. Topic: Discharge of debts in a high-stakes environment where multiple challenges impact a debtor's ability to meet financial obligations. Debtor files for Chapter 7 bankruptcy seeking to discharge significant debts including student loans, alimony payments, and tax obligations. The court reviews the case and determines which debts are eligible for discharge based on U.S. bankruptcy law. Which of the following debts can be discharged most easily under Chapter 7 bankruptcy? A. Unpaid federal income taxes from 2 years ago. B. Private student loan obtained 10 years ago with no history of repayment. C. Alimony payments owed to an ex-spouse. D. Credit card debt from personal account. Answer: D. Credit card debt from a personal account. Explanation: under the U.S. Bankruptcy Code, certain debts are generally non-dischargeable in a Chapter 7 bankruptcy. Here's how each option is assessed. A. Unpaid federal income taxes from 2 years ago. While some tax debts can be discharged, they must meet strict conditions under 11 U.S.C. SS 523A1. Taxes that are less than 3 years old are generally not dischargeable. The debtor would need to show the taxes meet the 3-year rule, 2-year rule, and 240-day rule before they can be discharged. B. Private student loan obtained 10 years ago with no history of repayment. Student loans, both federal and private, are extremely difficult to discharge. Under 11 U.S.C. SS 523A8, debtor must prove undue hardship, often requiring the Brunner test, which courts interpret very narrowly. C. Alimony payments owed to an ex-spouse. Domestic support obligations, including alimony and child support, are non-dischargeable under 11 U.S.C. SS 523A5. These payments are considered critical for supporting dependents and cannot be eliminated through bankruptcy. D. Credit card debt from personal account. General unsecured debts, such as credit card balances, are among the easiest to discharge in Chapter 7 bankruptcy. There are some exceptions, e.g. fraudulent charges, within 90 days of filing, but typically this type of debt is wiped out. This question tests the candidate's understanding of which debts can and cannot be discharged, crucial part of the bankruptcy process. Question 2. Topic: Avoidance powers and fraudulent transfers during a comprehensive review of a process that needs improvement. A bankruptcy trustee is analyzing a Chapter 7 debtor's recent financial transactions. The trustee discovers that 6 months before filing for bankruptcy, the debtor transferred $50,000 to a relative for no consideration. The trustee initiates an action under the Bankruptcy Code. Under which legal principle can the trustee recover this transfer? A. The absolute priority rule. B. Fraudulent conveyance under 11 U.S.C. SS 548. C. The automatic stay provision under 11 U.S.C. SS 362. D. Reaffirmation of debt under 11 U.S.C. SS 524. Answer: B. Fraudulent conveyance under 11 U.S.C. SS 548. Explanation: this question tests the concept of fraudulent transfers, which are attempts to move assets out of reach of creditors before filing for bankruptcy. Here's why each option is evaluated. A. The absolute priority rule. This rule applies to the distribution of assets in Chapter 11 reorganization cases, ensuring that secured and senior creditors get paid before unsecured creditors or equity holders. Does not apply to recovering fraudulent transfers. B. Fraudulent conveyance under 11 U.S.C. SS 548. This is the correct answer. The Bankruptcy Code allows trustee to void transfers made within 2 years of the filing if they were made with intent to hinder, delay, or defraud creditors, or if the debtor received less than reasonably equivalent value in return. Since the debtor transferred $50,000 for no consideration, it qualifies as constructive fraudulent transfer. C. The automatic stay provision under 11 U.S.C. SS 362. The automatic stay prevents creditors from pursuing collection efforts after bankruptcy filing, but it does not relate to avoiding fraudulent transfers. D. Reaffirmation of debt under 11 U.S.C. SS 524. Reaffirmation agreements involve debtor voluntarily agreeing to continue paying debt despite bankruptcy. This is unrelated to fraudulent transfers. This question highlights key trustee power under the Bankruptcy Code to claw back fraudulent transfers, an essential concept for bankruptcy litigation. Question 3. Topic: bankruptcy filing process in a situation where formal requirements conflict with debtor protections. A company facing severe financial distress is considering filing for Chapter 11 bankruptcy. However, a group of creditors, frustrated with the company's mismanagement, decides to initiate an involuntary bankruptcy petition against the debtor. Under what circumstances can creditors successfully force a business into involuntary bankruptcy under Chapter 11? A. At least 3 creditors must file a petition if the debtor has 12 or more creditors and the debts must be undisputed and exceed $10,000. B. At least 3 creditors must file a petition if the debtor has 12 or more creditors and the debts must be unsecured, undisputed, and exceed $18,600, adjusted periodically. C. A single creditor can force a company into involuntary bankruptcy as long as holds a claim exceeding $5,000. D. Creditors can only file an involuntary petition if the debtor has already missed at least 6 months of debt payments. Answer: B. At least 3 creditors must file a petition if the debtor has 12 or more creditors and the debts must be unsecured, undisputed, and exceed $18,600, adjusted periodically. Explanation: involuntary bankruptcy is a mechanism that allows creditors to initiate bankruptcy proceedings against a debtor who is failing to pay obligations. The key rules under 11 U.S.C. SS 303 include: A. At least 3 creditors must file petition if the debtor has 12 or more creditors and the debts must be undisputed and exceed $10,000. Incorrect. The debt threshold is higher than $10,000. It is periodically adjusted by law, currently around $18,600. B. At least 3 creditors must file petition if the debtor has 12 or more creditors and the debts must be secured, undisputed, and exceed $18,600. Correct under 11 U.S.C. SS 303. B. If the debtor has 12 or more creditors, then at least 3 creditors must file the petition and the total amount of their undisputed, unsecured claims must exceed $18,600, subject to periodic adjustments for inflation. C. Single creditor can force company into involuntary bankruptcy as long as it holds claim exceeding $5,000. Incorrect. Single creditor can file involuntary petition only if the debtor has fewer than 12 creditors and the claim exceeds $18,600, not $5,000. D. Creditors can only file an involuntary petition if the debtor has already missed at least 6 months of debt payments. Incorrect. The Bankruptcy Code does not impose strict 6-month delinquency rule for involuntary petitions. This question helps candidates understand involuntary bankruptcy concept in creditor-debtor relations. Question 4. During a comprehensive review of a process that needs improvement, a large corporation is undergoing Chapter 11 bankruptcy proceedings. The company, which owns multiple subsidiaries, has submitted a reorganization plan that includes the sale of a profitable subsidiary to pay off secured creditors. However, a group of unsecured creditors objects, arguing that the subsidiary is being sold for less than its fair market value and sale unfairly benefits secured creditors while leaving them with little to no recovery. The court is now faced with the decision of whether to approve the reorganization plan. Which of the following considerations is most relevant to the court's decision under Chapter 11? A. The absolute priority rule, which mandates that unsecured creditors must be paid in full before equity holders receive any distribution. B. The feasibility test, which requires the court to determine whether the reorganization plan is likely to succeed without the need for further financial restructuring. C. The best interests of creditors test, which ensures that unsecured creditors receive at least as much as they would in Chapter 7 liquidation. The cram-down provision, which allows the court to approve the plan over the objections of one or more classes of creditors. Answer: C. The best interests of creditors test, which ensures that unsecured creditors receive at least as much as they would in a Chapter 7 liquidation. Explanation: under 11 U.S.C. SS 1129A7 of the U.S. Bankruptcy Code, the best interests of creditors test requires that each creditor who does not accept the plan must receive at least as much as they would if the debtor were liquidated under Chapter 7. This is especially critical in cases where unsecured creditors argue that they are being unfairly treated in the distribution of assets. If the court determines that the sale of the subsidiary undervalues the assets, resulting in unsecured creditors receiving less than would in liquidation, the plan may not be confirmed. A. The absolute priority rule applies in Chapter 11 proceedings, but is mainly relevant when determining the order in which creditors and equity holders are paid. While it prevents equity holders from receiving distributions before creditors are paid in full, it does not necessarily determine whether sale price is fair. B. The feasibility test ensures that the company can operate under the plan without needing another bankruptcy filing soon after. While this is an important factor, it does not directly resolve disputes over asset valuation and creditor treatment. D. The cram-down provision 11U SC SS 1129 B. Allows confirmation of plan despite objections from certain creditor classes, but does not override the requirement that the plan must satisfy the best interests test. Question 5. When dealing with a complex system that shows occasional financial instability, a real estate development company files for Chapter 7 bankruptcy. The court-appointed trustee discovers that 6 months before the filing, the debtor transferred ownership of a high-value commercial property to a close family member for significantly less than its market value. The trustee seeks to void the transfer and bring the property back into the bankruptcy estate. The debtor argues that the transfer was legitimate and necessary to settle an unrelated personal debt. Which of the following legal principles will the trustee most likely rely on to challenge the transfer? A. The doctrine of equitable subordination. B. The preference rule under 11U SC SS 547. C. The fraudulent transfer rule under 11U SC SS 548. D. The automatic stay provision under 11U SC SS 362. Answer C. The fraudulent transfer rule under 11 U.S.C. SS 548. Explanation. Under 11 U.S.C. SS 548. Fraudulent transfers occur when debtor transfers property with the intent to hinder, delay, or defraud creditors, or receives less than reasonably equivalent value for the transfer while being insolvent. Since the debtor transferred valuable asset for much less than its market value to close relative shortly before filing for bankruptcy, this is a classic example of constructively fraudulent transfer that the trustee can challenge. A. The doctrine of equitable subordination applies when creditor has engaged in misconduct and their claims should be subordinated to other creditors. This principle does not address asset transfers. B. The preference rule under 11 U.S.C. SS 547 allows the trustee to recover payments made to creditors within 90 days of filing that give them an advantage over other creditors. However, fraudulent transfers typically involve improper conveyance of property, not payments favoring certain creditors. D. The automatic stay provision under 11 U.S.C. SS 362 halts collection activities against the debtor but does not apply to past transactions that occurred before the bankruptcy filing. Question 6. During an emergency response where multiple areas are impacted, a bankruptcy judge is considering whether to discharge a debtor's tax debt in Chapter 7 proceeding. The debtor argues that the tax debt is over 3 years old and should therefore be dischargeable. The IRS, however, opposes the discharge, claiming that the debtor failed to file tax returns on time and that the debt should remain non-dischargeable. Under the U.S. Bankruptcy Code, which of the following conditions would allow the tax debt to be discharged? A. The debtor filed the tax return at least 2 years before filing for bankruptcy and the tax debt is at least 3 years old. B. The tax debt is related to unpaid payroll taxes rather than income taxes. C. The debtor's financial hardship is extreme, making repayment impossible. D. The tax debt is owed to foreign government rather than the IRS. Answer. A. The debtor filed the tax return at least 2 years before filing for bankruptcy and the tax debt is at least 3 years old. Explanation. Under 11 U.S.C. SS 523A 1. Tax debts can only be discharged in Chapter 7 bankruptcy if they meet specific criteria. The tax must be at least 3 years old. The 3-year rule. The debtor must have filed the tax return at least 2 years before the bankruptcy filing. The 2-year rule. The IRA must have assessed the tax at least 240 days before the filing. The 240-day rule. Since the debtor argues tax debt is over 3 years old, the court must also consider whether they filed their returns at least 2 years before filing for bankruptcy. If they did not, the tax debt remains non-dischargeable. B. Payroll taxes are never dischargeable under Bankruptcy Law 11 U.S.C. SS 507A 8C. C. Extreme financial hardship does not automatically discharge tax debts unless specific undue hardship conditions under 26 U.S.C. SS 6343 are met, which is rare. D. Tax debts owed to foreign governments are generally non-dischargeable unless specific treaty allows discharge. Question 7. During a strategic planning meeting focused on long-term financial stability, a company is evaluating the impact of secured versus unsecured debt in a potential bankruptcy scenario. The CFO explains that one of the company's major loans is backed by warehouse property, while several other loans are based only on the company's general creditworthiness. The board wants to understand how these differences will affect creditor repayment. Company files for Chapter 7 bankruptcy. Which of the following best describes how secured and unsecured creditors will be treated in Chapter 7 proceedings? A. Secured creditors will have priority over unsecured creditors and can recover their claims directly from the collateral before unsecured creditors receive any distribution. B. Unsecured creditors will receive payment first to ensure equitable distribution among all creditors before secured creditors can enforce their claims. C. Secured and unsecured creditors are treated equally under Chapter 7, and distributions are made based on the percentage of owed. D. Secured creditors are prohibited from enforcing their security interests once the bankruptcy process begins. Answer. A. Secured creditors will have priority over unsecured creditors and can recover their claims directly from the collateral before unsecured creditors receive any distribution. Explanation. Under Chapter 7 of the U.S. Bankruptcy Code, secured creditors have a lien on specific assets, meaning they have the legal right to recover their debt from the collateral first. If the value of the collateral is insufficient to cover the entire secured debt, the remaining balance may be treated as unsecured debt. B. Unsecured creditors do not receive payment before secured creditors. They are typically paid from any remaining funds after secured creditors are satisfied. C. Secured. The secured creditors are not treated equally. Secured creditors have priority because their loans are backed by collateral. D. Secured creditors can enforce their security interests even during bankruptcy, though they may need court approval if the automatic stay applies. Question 8. When evaluating potential risks associated with a new business strategy, a retail company enters into a Chapter 11 bankruptcy restructuring. The company's reorganization plan includes renegotiating leases with commercial landlords to reduce rental expenses. Some landlords refuse to negotiate and demand full payment of remaining lease obligations. Under the U.S. Bankruptcy Code, which of the following best describes the company's options regarding its commercial leases? A. The company must continue paying rent in full under all lease agreements even after filing for Chapter 11. B. The company can assume, reject, or assign its commercial leases as part of the bankruptcy process, subject to court approval. C. The company is automatically released from all lease obligations upon filing for Chapter 11 bankruptcy. D. The company must pay all past due rent immediately, but can negotiate future without landlord approval. Answer. B. The company can assume, reject, or assign its commercial leases as part of the bankruptcy process, subject to court approval. Explanation. Under 11 U.S.C. SS 365, debtor in Chapter 11 bankruptcy has the right to assume, reject, or assign commercial leases. If the lease is assumed, the company agrees to continue making payments and cure any past defaults. If the lease is rejected, it is treated as breach of contract and the landlord becomes an unsecured creditor for damages. If the lease is assigned, the company transfers it to another party, but the assignee must provide adequate future performance. A. The company does not have to pay full rent on all leases if they are rejected. C. Filing for Chapter 11 does not automatically terminate lease obligations. D. The company does not have to pay all past due rent immediately unless it assumes the lease. Question 9. When an organization considers external factors that may impact operations, a financial institution providing loans to distressed businesses wants to evaluate the risks associated with lending to a company in financial trouble. The institution is particularly concerned about preferential transfers and whether loan repayments could be challenged in a future bankruptcy case. Under the U.S. Bankruptcy Code, which of the following scenarios best describes a preferential transfer that could be avoided by a bankruptcy trustee? A. A debtor makes a payment to an unsecured creditor 60 days before filing for bankruptcy, resulting in that creditor receiving more than they would in Chapter 7. B. A debtor pays rent for its commercial property in advance as part of its normal course of business. C. A debtor repays a secured loan with collateral that was already pledged to the lender. D. A debtor enters into a new financing agreement with a lender who is fully aware of its financial condition. Answer. A debtor makes a payment to an unsecured creditor 60 days before filing for bankruptcy, resulting in that creditor receiving more than they would in Chapter 7. Explanation. Under 11 U.S.C. SS 547, preferential transfer occurs when the debtor transfers property, including payments, to creditor. The transfer occurs within 90 days before bankruptcy or 1 year if the creditor is an insider. The transfer is made while the debtor is insolvent and the creditor receives more than they would in Chapter 7 liquidation. B. Normal business transactions, such as rent payments, are not considered preferential transfers. Repayment of secured loans with collateral is not preference because secured creditors have legal right to their collateral. D. Entering into new financing agreement is not preferential transfer, though it may be subject to scrutiny under fraudulent transfer rules. Question 10. During an in-depth discussion on managing financial risk, a business owner is considering filing for Chapter 13 bankruptcy to reorganize personal debts. However, the business owner's attorney warns that not all types of debt can be discharged under Chapter 13. Which of the following types of debt is most likely to remain non-dischargeable in Chapter 13 bankruptcy? A judgment from personal injury lawsuit resulting from the debtor's negligence. B. Student loan debt, unless the debtor can prove undue hardship. C. Credit card debt used for business expenses. D. Home mortgage loan that the debtor intends to reaffirm. Answer. B. Student loan debt, unless the debtor can prove undue hardship. Explanation. Under 11 U.S.C. SS 523A8. Student loan debt is generally non-dischargeable unless the debtor can prove undue hardship under the Bronner test, which requires showing the debtor cannot maintain minimal standard of living while repaying the loans, the debtor's financial situation is unlikely to improve, and the debtor has made good faith efforts to repay the loans. A personal injury judgments from negligence are generally dischargeable in Chapter 13 unless they involve willful misconduct, e.g., due-related injuries. C. Business-related credit card debt is usually dischargeable. D. Home mortgage loan is not discharged if the debtor chooses to reaffirm it, but it can be restructured under Chapter 13. Question 11. When a company evaluates potential liabilities related to contract breaches, an electronics manufacturer enters into a supply agreement with a vendor requiring the vendor to deliver components every month for 2 years. After 6 months, the manufacturer realizes it no longer needs the components and wants to cancel the contract. The vendor, however, insists on full payment for the remaining term. Under contract law, which of the following options best describes the potential legal consequences for the manufacturer if they terminate the agreement? A. The manufacturer is required to pay the full contract price regardless of future deliveries. B. The manufacturer may terminate the contract but must compensate the vendor for any damages, including lost profits. C. The manufacturer can cancel the contract without liability because they no longer need the components. D. The manufacturer must continue purchasing components but may renegotiate pricing terms. Answer. B. The manufacturer may terminate the contract but must compensate the vendor for any damages, including lost profits. Explanation. Under contract law, if one party unilaterally breaches an agreement without just cause, the non-breaching party is entitled to damages. The vendor is entitled to damages for lost profits from expected future sales as long as they can prove the damages with reasonable certainty. The manufacturer cannot cancel the contract without liability, eliminating option C, because lack of need is not a valid defense for breach of contract. The vendor is not automatically entitled to the full contract price, eliminating option A, unless the contract explicitly states that termination requires full payment. While renegotiating pricing terms, option D is possible. The vendor is not obligated to agree. Question 12. During a corporate restructuring that affects employee benefits, a large retail company reduces its workforce and modifies its severance pay policy. Some employees claim they are entitled to higher severance under their original contracts, while the company argues that the new policy overrides prior agreements. Under employment law, which of the following factors would most likely determine whether the company must honor the original severance agreements? A. Whether the severance terms were part of an individual contract or a company-wide policy. B. The company's financial condition at the time of termination. C. Whether the employees previously received severance payments from the company. D. The number of employees affected by the restructuring. Answer. A. Whether the severance terms were part of an individual contract or a company-wide policy. Explanation. If severance terms were part of an individual contract, the company must honor the original agreement unless the contract allows modifications. If severance was part of a company-wide policy, the company may legally change the policy before termination as long as it follows proper notification procedures. B. The company's fine. Condition is not determining factor. Contractual obligations remain enforceable unless bankruptcy is involved. C. Prior severance payments do not impact the validity of future agreements. D. The number of affected employees is irrelevant unless it triggers labor law protections, such as the WARN Act, which applies to mass layoffs. Question 13. When a financial institution assesses credit risk in consumer lending, a bank offers a mortgage to a borrower who has a history of missed payments but a strong current income. The borrower later defaults, and the bank wants to understand how debt-to-income (DTI) ratios impact default risk. Which of the following best describes how DTI ratios are important in evaluating loan risk? A. A lower ETI ratio indicates that the borrower has less debt relative to income, reducing the risk of default. B. A higher ETI ratio increases a borrower's credit score, making default less likely. C. DTI ratios only apply to business loans, not personal mortgages. D. Borrower with high DTI ratio is more likely to qualify for mortgage due to their experience handling debt. Answer A. A low DTI ratio indicates that the borrower has less debt relative to income, reducing the risk of default. Explanation: DTI equals total monthly debt payments, gross monthly income. Low TIE. G. 30% suggests that the borrower has more disposable income to cover new debt, reducing the risk of default. High DTI. G. 50% or more means the borrower is using large portion of their income. Existing debt increasing the likelihood of financial distress. B. High DTI does not increase credit scores. It typically makes borrowing more difficult. C. DTI ratios are relevant for all loans, including mortgages. D. High DTI does not improve mortgage eligibility. Lenders prefer lower DTI to ensure repayment ability. Question 14. During an in-depth discussion on consumer protection laws, a customer sues an auto dealership for selling a used car that had undisclosed flood damage. The dealership claims it was unaware of the damage at the time of sale. Under the Magnuson-Moss Warranty Act, which of the following would most likely determine the dealership's liability? A. Whether the car was sold, as is without any express or implied warranties. B. Whether the customer has driven the car for more than 10,000 miles. C. Whether the dealership knew about the flood damage before the sale. D. Whether the customer had an independent mechanic inspect the car before purchase. Answer A. Whether the car was sold, as is without any express or implied warranties. Explanation: if the car was sold, as is if the buyer assumes the risk and the dealership is typically not liable unless fraud or deception occurred. If the dealership provided any warranty, even implied, it must disclose known defects and cannot misrepresent the vehicle's condition. B. The number of miles driven is not defensive warranty was violated. C. The dealership's knowledge is relevant only if fraud is alleged, but lack of knowledge does not automatically prevent liability. D. Independent inspection does not eliminate liability for undisclosed defects under warranty. Question 15. When a company evaluates the financial impact of a product recall, a food manufacturer discovers that one of its products is contaminated and issues a recall. The company is concerned about potential lawsuits, reputational damage, and financial losses. Which of the following best describes the company's legal obligations and financial risks under product liability law? A. The company is only liable for damages if the contamination was intentional. B. The company must compensate affected consumers, regardless of whether it was negligent. C. The company is not liable if it provided warning labels about potential risks. D. The company must reimburse retailers for unsold recalled products, but does not owe damages to consumers. Answer: B. The company must compensate affected consumers, regardless of whether it was negligent. Explanation: under strict product liability, a manufacturer is responsible for injuries caused by defective or contaminated products, even if it was not negligent. A. Intent is not required for liability. A harm alone is sufficient. C. Warning labels do not protect against liability for contamination. Warnings apply to known risks, not manufacturing defects. D. The company is also liable for consumer damages, not just retailer losses. Question 16. When an investor analyzes the impact of interest rate changes on bond prices, they notice that long-term bonds seem to fluctuate more in value than short-term bonds. Which of the following best explains why long-term bonds are more sensitive to interest rate changes? A. Long-term bonds have lower credit risk, making them more volatile. B. Long-term bonds lock in interest rates for A longer period, making them more sensitive to market rate changes. C. Short-term bonds are riskier investments, making them more stable in price. D. Interest rate changes only affect newly issued bonds, not existing bonds. Answer B. Long-term bonds lock in interest rates for a longer period, making them more sensitive to market rate changes. Explanation: bond prices and interest rates move inversely. Long-term bonds are affected more because their fixed interest payments become less attractive when rates rise. 8. Credit risk does not explain interest rate sensitivity. It relates to default risk. C. Short-term bonds are not riskier. They have lower interest rate sensitivity. D. Interest rate changes affect both old and new bonds, impacting their market value. Question 17. During a discussion on corporate governance and shareholder rights, an investor challenges a board decision to approve a merger without shareholder approval. The company argues that it was not required to seek shareholder input. Under corporate law, which of the following factors most likely determines whether shareholders must vote on the merger? A. Whether the company is privately held or publicly traded. B. The size and financial impact of the merger on the company. C. Whether the merger changes shareholder ownership rights or dilutes their shares. D. The number of years the company has been in business. Answer C. Whether the merger changes shareholder ownership rights or dilutes their shares. Explanation: shareholder approval is typically required if the merger significantly alters their rights, such as issuing new shares or changing control. 8. Public versus private status does not determine voting rights. It depends on company bylaws and securities regulations. B. Financial impact alone is not enough to require vote unless it affects ownership. D. The company's age does not determine shareholder rights. Question 18. When an insurance company assesses claims under property damage policies, a homeowner files a claim for storm damage to their roof. The insurer denies the claim, citing pre-existing wear and tear. Under insurance law, which of the following factors would most likely determine whether the insurer must pay the claim? A. The type of policy exclusions listed in the homeowner's insurance contract. B. The age of the homeowner's roof at the time of the storm. C. The homeowner's credit score and prior claim history. D. The amount of money the homeowner spent on home maintenance before the storm. Answer A. The type of policy exclusions listed in the homeowner's insurance contract. Explanation: insurance contracts often exclude coverage for wear and tear but cover sudden and accidental damage, such as storms. B. The age of the roof matters only if the policy excludes older roofs from coverage. C. Credit scores and claim history affect premiums, not coverage decisions. D. Maintenance is important but does not determine claim unless negligence contributed to the damage. Question 19. During a regulatory investigation into consumer lending practices, a bank is accused of charging excessive fees and misleading borrowers about loan terms. Under consumer protection laws, which of the following most likely determines whether the bank engaged in unlawful practices? A. Whether the fees charged were higher than competitors' fees. B. Whether the fees and terms were clearly disclosed in loan agreements. C. The income level of the borrowers affected by the fees. D. The number of customer complaints received about the fees. Answer B. Whether the fees and terms were clearly disclosed in loan agreements. Explanation: consumer protection laws such as Truth in Lending Act require clear disclosure of fees, interest rates, and repayment terms. A. High fees alone do not violate laws unless they are deceptive or unfair. C. Borrower income does not affect whether fees are lawful. D. Complaints indicate consumer dissatisfaction but do not prove a legal violation. Question 20. When a company considers ethical concerns related to data privacy, it launches a new app that collects user data for targeted advertising. Some users complain that they were not informed about data collection. Which of the following best describes an ethical approach to handling user data? A. Collect as much data as possible to improve advertising accuracy regardless of user preferences. B. Disclose data collection practices in the app's terms and conditions, even if most users do not read them. C. Provide clear upfront notifications and allow users to opt out of data collection. D. Sell user data only to trusted third parties who follow industry regulations. Answer C. Provide clear upfront notifications and allow users to opt out of data collection. Explanation: ethical data privacy practices require transparency and user control over personal information. A. Collecting excessive data without user consent violates privacy principles. B. Terms and conditions are often ignored. Clear notifications are more ethical. D. Selling data even legally may still violate user trust. Question 21. During a major transformation where existing methods are being phased out, an organization introduces a cloud-based project management system to replace its traditional paper-based tracking. Some employees resisted change, citing concerns about usability and security. Which of the following strategies would most effectively address employee resistance to the transition? A. Mandating immediate use of the new system and disabling the old system. B. Conducting training sessions, offering ongoing support and addressing concerns. C. Allowing employees to choose between the old and new system indefinitely. D. Reverting back to the paper-based system due to the resistance. Answer: B. Conducting training sessions, offering ongoing support, and addressing concerns. Explanation: employee resistance is natural during major transitions. Forcing immediate adoption creates frustration and reduces productivity. C. Allowing indefinite choice slows full adoption and keeps inefficiencies. D. Reverting eliminates the benefits of the transition. Best approach: training, support, and addressing security concerns ensure smoother adoption. Question 22. When implementing new protocols in a shared environment, a hospital updates its patient record system to comply with new regulations. However, different departments struggle to integrate their workflows. Which of the following should be the first step to ensure smooth implementation? A. Conducting a department-wide needs assessment before finalizing the new protocol. B. Requiring all departments to adjust to the new system immediately. C. Allowing each department to implement the system in its own way. D. Waiting to introduce the system until all departments agree on its usage. Answer: A. Conducting a department-wide needs assessment before finalizing the new protocol. Explanation: change management requires understanding department-specific challenges. B. Immediate adjustment leads to confusion and errors. C. Different implementations could cause inconsistencies. D. Waiting indefinitely can delay critical compliance improvements. Question 23. In a case where multiple parties have different objectives, a company's marketing and finance teams disagree over budgeting for an upcoming product launch. Marketing wants more funds for promotion, while finance wants cost control. Which approach would best balance both interests? A. Reducing the marketing budget and allocating more funds to finance. B. Giving full budget control to marketing since they drive revenue. C. Creating collaborative budgeting process that aligns financial goals with marketing needs. D. Postponing the launch until both departments agree on compromise. Answer: C. Creating a collaborative budgeting process that aligns financial goals with marketing needs. Explanation: cross-functional collaboration ensures both revenue growth and budget control. A. Cutting marketing budget may reduce campaign effectiveness. B. Marketing alone cannot determine overall financial sustainability. D. Delaying a launch can cause lost revenue opportunities. Question 24. While analyzing the root causes of sequential problems in a supply chain, a manufacturer experiences repeated shipment delays due to warehouse inefficiencies and transportation bottlenecks. Which of the following would be the most effective first step to address these problems? A. Increasing warehouse staffing to speed up packing. B. Implementing a comprehensive supply chain analysis to identify bottlenecks. C. Switching shipping partners to improve transportation reliability. D. Penalizing warehouse workers for slow processing. Answer: B. Implementing a comprehensive supply chain analysis to identify bottlenecks. Explanation: understanding the full problem before acting is key. A. Increasing staff may not solve deeper inefficiencies. C. Shipping issues may not be the only cause of delays. D. Penalizing workers without addressing workflow issues is ineffective. Question 25. In a high-stakes environment where multiple challenges arise simultaneously, a financial firm faces cybersecurity threats while also experiencing regulatory pressure to enhance data protection policies. What is the most effective strategy to manage these challenges? A. Address cybersecurity threats first, delaying regulatory compliance efforts. B. Prioritize compliance efforts and assume cybersecurity risks will decrease. C. Develop an integrated approach that addresses both cybersecurity and compliance together. D. Ignore cybersecurity concerns since compliance is the legal priority. Answer: C. Develop an integrated approach that addresses both cybersecurity and compliance together. Explanation: regulatory compliance and cybersecurity are interconnected. A. Ignoring compliance can lead to legal consequences. B. Compliance alone does not prevent security breaches. D. Cybersecurity threats can lead to major financial and reputational damage. Question 26. During an emergency response where multiple areas are impacted, a large-scale power outage disrupts hospital operations, public services, and communication networks. Which of the following is the most important first action for emergency managers? A. Restoring power to residential areas first. B. Coordinating with medical facilities to ensure life-saving equipment remains functional. C. Issuing public service announcements about estimated restoration times. D. Focusing on financial recovery efforts for affected businesses. Answer: B. Coordinating with medical facilities to ensure life-saving equipment remains functional. Explanation: preserving human life is the highest priority in emergencies. A. Residential power can be restored later. C. Communication is important but secondary. D. Financial recovery follows after immediate risks are handled. Question 27. When improving, a process that shows unexpected results, a retail company notices a sudden drop in online sales after a website redesign. What is the best first step to diagnose the issue? A. Immediately rolling back to the old website version. B. Conducting user experience testing to identify usability issues. C. Increasing advertising spending to drive traffic. D. Changing product pricing to attract more buyers. Answer: B. Conducting user experience testing to identify usability issues. Explanation: user experience issues could be the root cause. Rolling back removes improvements without addressing the issue. C. More ads won't fix broken website experience. D. Pricing may not be the issue if users can't navigate the site. Question 28. In an environment where different components must interact seamlessly, a software company integrates a new billing system with its existing customer database, but users report frequent billing errors. What should be the first step in resolving the issue? A. Manually correcting errors for affected customers. B. Conducting a system-wide audit to identify integration failures. C. Training employees to work around system limitations. D. Shutting down the new system and reverting to manual billing. Answer: B. Conducting a system-wide audit to identify integration failures. Explanation: auditing identifies technical issues causing errors. A. Manual corrections don't address the underlying issue. C. Workarounds don't fix the root problem. D. Reverting removes progress without diagnosing the cause. Question 29. While examining inconsistencies across various units, a multinational corporation finds that its regional offices report vastly different customer satisfaction scores despite following the same service guidelines. What would be the most effective approach to determine the cause of these inconsistencies? A. Standardizing all customer service interactions and eliminating regional variations. B. Conducting regional assessments to identify factors affecting satisfaction levels. C. Increasing staff training hours across all offices to ensure uniform service quality. D. Assuming cultural differences are the cause and making no changes. Answer: B. Conducting regional assessments to identify factors affecting satisfaction levels. Explanation: variations in customer satisfaction scores may be due to local market conditions, staffing levels, or service expectations. A. Standardization may not address unique regional needs. C. Training alone does not fix structural or operational differences. D. Assuming cultural differences without investigation can lead to missed opportunities for improvement. Question 30. When scaling up operations that experience significant bottlenecks, a logistics company expands its delivery network but faces growing delays due to increased demand. Which action would be the most effective first step in reducing these delays? A. Hiring additional drivers and warehouse staff immediately. B. Analyzing delivery routes and warehouse processing times to optimize efficiency. C. Reducing service areas to focus on core locations. D. Raising delivery prices to decrease order volume. Answer: B. Analyzing delivery routes and warehouse processing times to optimize efficiency. Explanation: understanding bottlenecks before taking action prevents wasted resources. A. Hiring more staff may help, but only if inefficiencies are first identified. C. Reducing service areas limits business growth. D. Raising prices to reduce demand can harm customer relationships.